In order to maintain a claim of negligence, the plaintiff must prove duty, breach, causation, and damages. Duty, rule. People in Florida have a duty to all foreseeable plaintiffs. The duty is to act as a reasonable prudent person, and this is an objective standard. Breach. When a person deviates from the applicable standard of care, they are in breach. Causation. In Florida, there is causation if there is both cause in fact and proximate cause. But for causation is actual causation, but for the defendant's negligence, plaintiff would not have been harmed. However, when there are two or more actors responsible for indivisible injury, the actual cause test is met as long as the defendant's actions were a substantial factor in causing harm to the plaintiff. Proximate cause focuses on foreseeability. The question is whether the harm that resulted was a foreseeable consequence of the act that made defendant's actions negligent in the first place. Damages. In Florida, the measure of damages for negligence is compensatory damages. Compensatory damages are the damages necessary to put plaintiff back into the position they were in before the negligence occurred in order to make them whole. There must be physical harm or harm to property. Pure economic loss is insufficient for negligence. However, should the plaintiff prove the requisite injury, then they are entitled to non-economic damages like pain and suffering, but also economic damages like medical expenses and lost wages. Vicarious liability. An employer is liable to an employee who causes harm to another when they are acting within the course and scope of their employment. Joint and several liability. At common law, a defendant could be held jointly and severally liable with co-tortfeasors. This meant that the plaintiff could go after any one defendant for all of the harm and the defendant could then sue the co-defendant for their portion of the damages. However, Florida has abolished joint and several liability. As such, each defendant is only liable for their own proportional share of the harm. Contributory/comparative negligence. Florida is a pure comparative fault jurisdiction. This means that the plaintiff can still recover even if they were more at fault than the defendants. The plaintiff's share of fault would reduce their overall recovery. However, if the plaintiff were legally drunk and more than 50% at fault, then they would be barred from recovering. Intervening and superseding causes. After the defendant's negligence, the defendant will be liable for all harm that is foreseeable. Foreseeable harm is called an intervening cause. Superseding causes, however, are not foreseeable and cut off the defendant's liability. Superseding causes are things like acts of God, intentional torts by third parties, and crimes by third parties. Negligence of others is foreseeable. Negligent infliction of emotional distress. If a defendant places a plaintiff in the zone of danger, then a plaintiff may recover for severe emotional distress if there is a physical impact, or there is a physical manifestation of symptoms. If the plaintiff is a bystander, then there is still a way to recover for NIED. That is, the bystander plaintiff must have been closely related to the victim, the plaintiff must have 41 been in the presence of the victim, and the plaintiff must have perceived the injury. Intentional infliction of emotional distress. To recover for intentional infliction of emotional distress, IIED, the plaintiff needs to prove that the defendant acted intentionally or recklessly with extreme and outrageous conduct to cause plaintiff severe emotional distress, and that plaintiff did suffer severe emotional distress. Extreme and outrageous conduct is conduct outside the bounds of civilized society. In addition, plaintiff does not need to manifest physical symptoms. Battery. To bring a battery claim, the plaintiff needs to show that the defendant intentionally caused a harmful or offensive contact with plaintiff or plaintiff's person, and that such contact occurred. Defamatory statement, fault. A public figure must prove that the defendant made the defamatory statement with actual malice, that is, knowledge that the statement was false or reckless disregard for the truth. If plaintiff is a private figure, then all they must prove is negligence. A public figure is generally a celebrity or someone who holds themselves out to the public or involves themselves in topics of public concern. Libel versus slander. Libel is printed defamation, slander is spoken. Slander requires actual proof of damages and less slander per se, while libel does not require such proof. However, libel by a media defendant does require proof of damages, and damages are never presumed. Furthermore, against a media defendant, the plaintiff can send a request for a retraction, and, if the media defendant complies, then plaintiff is limited only to actual damages. Negligence. Waiver. A waiver also requires the party, A-B here, disclose the danger, note that the activity is inherently dangerous and further note that it cannot be made safe even by the exercise of due caution on the part of A-B. A person may waive certain rights, including those regarding damages flowing from the dangerous activity. Punitive damages. Punitive damages must be pleaded specifically and are permitted when the trier of fact finds that the defendant acted intentionally or with gross negligence. Punitive damages are capped at the greater of $500,000 or 2x special damages. In limited circumstances when the plaintiff can show the defendant knew of the risk and decided to proceed for purely pecuniary reasons, the plaintiff may recover $2 million or 4x special damages. Defamation. In order to prove a case of defamation, the plaintiff must prove 1. False statement of fact, 2. Identification of the plaintiff as the subject. 3. Publication to a third party. 4. Fault on the part of the defendant for a private person, negligence, and for a public figure express malice reckless disregard for the truth of the statement or knowledge of its falsity. 5. Defamatory effect of the statement. And 6. Damages. Where the defendant is the media, at least 5 days prior to the filing of a lawsuit, the plaintiff must give the defendant written notice, specifying the alleged defamatory statement. Upon receipt, the defendant then has 10 days to fully retract the statement, and if the statement was made in good faith and there is a retraction, the plaintiff may only recover actual damages. Invasion of privacy. Dara will likely bring a claim against the Orlando Star for invasion of privacy. Included in the tort of invasion of privacy is intrusion into plaintiff's private affairs or seclusion. Intrusion into plaintiff's private affairs requires an actual intrusion into something that a reasonable person would keep private. Defamation. Defamation is an actionable tort which arises when the defendant, I, makes a defamatory statement, 2, of or concerning the plaintiff, 3, and there is publication of the statement. A defamatory statement is a statement of fact that either on its face negatively reflects on the plaintiff or where the statement would lead a reasonable person to infer a negative defamatory fact about the plaintiff. As a general rule, damages need not be shown to make out a prima facie case for libel, defamation published in a permanent form, e.g. in a writing or video. Damages must be proven for slander, spoken publication of defamation statement, unless the slander is 9 per se actionable because it meets one of the slander per se definitions. Slander that negatively reflects on plaintiff's business or employment is slander per se. Generally, falsity of the statement and fault, i.e., some degree of culpable negligence or intent, need only be proven if the defamatory statement concerns a matter of public concern or a public figure. Intentional infliction of emotional distress. Intentional infliction of emotional distress requires, I, extreme and outrageous conduct, exceeds all bounds of decency in society, 2, knowledge or reasonable expectation that the conduct would result in emotional distress to plaintiff, and 3, plaintiff must actually experience emotional distress. Negligence. The elements of a claim for negligence are duty, breach, causation, and damages. A negligence claim based on a property owner's liability for people using the owner's property is a premises liability claim. An owner of property in Florida is responsible for ensuring the reasonable safety of its visitors. Duty. The standard of care owed to a visitor depends on which type of visitor they are. Invitees are owed the highest duty of care. A premises owner has a duty to reasonably inspect the premises, warn of any unknown dangers, and protect against known dangers to invitees. Licensees are owed a lesser duty of care, and known or unknown trespassers even less. The only duty owed to an unknown trespasser is not to intentionally cause the trespasser harm. Licensees are owed the duty to warn of known hidden defects. Invitee. A duty can arise from a number of different relationships. Duties can be contracted for, they can be statutory, or can arise from a specific type of relationship, such as parent/child or teacher/student. As mentioned above, the duty owed to Val and Fred by Toolmart is that owed to a business invitee. A duty to a business invitee only goes to the extent of the invitation. If Fred were to wander into an employee's-only area and become injured, he would likely not be able to bring a claim against Toolmart as he would have exceeded the scope of the invitation. Causation. Causation includes the but for and the proximate cause. The but for cause shows that the injury would not have occurred but for defendant's negligence. The proximate cause shows that the defendant's negligence was the actual cause of the plaintiff's injuries. Damages. Damages must be shown to complete a negligence action. Plaintiffs are entitled to recover for their actual damages, future damages, and medical care, and pain and suffering. Attorney's fees can be granted based on proposals for settlement or fraud or misconduct during litigation. Negligent impairment of security and waste. Negligence is a cause of action which requires 1. Duty, 2. Breach, 3. Causation, both proximate and in fact, and 4. Damages. A driver has a duty to use reasonable care to protect foreseeable plaintiffs from harm. A holder of a security interest in the car being driven is a foreseeable plaintiff for any damage sustained to the car as a result of its being driven. A breach occurs where the defendant fails to use reasonable care. Cause in fact is when the injury would not have occurred, but for the negligence, and lastly proximate cause is met provided the injury is a foreseeable result of the breach. There must, as is obvious, be damages. Negligence premises liability. Negligence is 1. Duty, 2. Breach, 3. Causation, and 4. Damages. Because the facts indicate Paula was injured in a supermarket, the rules of premises liability for commercial business owners apply. To successfully breach a cause of action for negligence, Paula has the burden of establishing the following. 1. Duty. The issue is whether the defendant, supermarket, owed a duty to Paula. Generally, a duty is owed to all foreseeable victims. The classification of the plaintiff will establish the specific standard of care owed by supermarket. Florida has abolished the distinction between licensees and invitees. Rather, victims who are on the premises lawfully and have not exceeded the scope of their invitation on the property, ex-trespassers, are all classified as invitees. Duty of invitee. The duty to invitees is to keep the premises reasonably safe for the benefit of the invitee, warn of latent or non-readily observable defects known to the landowner, and make reasonable inspections to and make safe any dangerous conditions on the land. Further, commercial business owners owe a heightened duty of care to victims than residential commercial landowners are required. Business owners must also keep the premises free from any movably or transitory substances and unreasonably dangerous artificial or natural conditions to any invitee on the property and others adjacent to the premises. Breach. 2. Breach. The issue is whether supermarket breached that duty to Paula, as an invitee, when she slipped and fell on the melted ice cream on the floor. As discussed above, business owners owe a duty to keep the premises free from transitory substances. Likewise, the supermarket also owed a duty to make reasonable inspections to uncover such dangerous conditions. It is not necessary, then, that the supermarket had actual notice of the condition as long as it could have been uncovered by reasonable inspection. Causation/damages. 3-4. Causation/damages. The most problematic issue that Paula will have is proving that supermarket's breach was the legal and proximate cause of the injuries to her head. Causation is the legal and factual cause of their injuries. But 4. Test is the factual cause. Proximate cause is the natural and foreseeable event of defendant's acts. Eggshell. Under the eggshell plaintiff theory, a defendant takes the victim in whatever the fragility of the condition. Comparative negligence. 1. Comparative negligence. Florida courts have adopted the pure comparative negligence method. Under this, the supermarket may assert that Paula was comparatively negligent when she was walking through the supermarket. The supermarket may also assert that the husband's negligence while driving made him liable for the injuries. Damages. In a negligence suit, a plaintiff may recover compensatory damages as a result of any medical expenses and pain and suffering. Punitive damages are ordinarily not available unless more blameworthy conduct is at issue, like fragile plaintiffs or intentional torts. Conversion. Conversion is a remedy permitted by the courts for an indorser who was entitled to payment but did not receive the payment. Conversion is the substantial interference of one's property. However, with conversion, the indorser must have actual possession over the check. Strict products liability of one's property. However, with conversion, the indorser, for liability to stand, she would need to show that manufacturer is in the business of making and selling such products, that the product is unreasonably dangerous to an average consumer. Causation and damages. Design defect. Under design defect is failure to warn or instruct. Amy has a strong case of showing duty/breach under strict liability. Joint and several liability. Note, Florida has abolished joint and several liability for negligence and strict liability, so the damages would be apportioned by the court. Product liability. Strict liability applies when the activity is abnormally dangerous, a defect is present, or animals are involved. A defect can either be a design defect, manufacturing defect, or failure to label. A seller of items, who sells the defective item in its usual course of business, is generally strictly liable for defects. A merchant is not liable for a defect unless they knew of or should have known of the defect. It does not matter that dealer was not in privity with employee or s. Privity of contract is not required for strict liability claims. Duty owed to all foreseeable plaintiffs to act as a reasonably prudent person under the same or similar circumstances. Breach when defendant's conduct falls below the duty owed. Causation. A must be the legal causation, the buffer causation, and the proximate cause. Damages. Defendant must incur actual damages, not just economic loss. Florida allows for recovery of compensatory damages in the form of economic, lost wages, medical bills, and non-economic, pain and suffering, loss of consortium. Florida, unlike a majority of states, allows recovery of pain and suffering in wrongful death actions for the surviving spouse and any minor children. Punitive damages. In Florida, punitive damages must be plead with specificity to the trier of fact, who must find by clear and convincing evidence that the individual is guilty of intentional misconduct or gross negligence. For an employer or other individual to be liable for punitive damages due to a contractual or agency relationship, the principal, or A&R situation, must have either 1. Condoned or ratified the conduct, 2. Participated in conduct that lead to the injuries, or 3. Been grossly negligent. Vicarious liability. Vicarious liability is holding an individual accountable/liable for the acts of its agent or employee. Comparative negligence. Florida is a pure comparative negligence state. Plaintiff can bring a claim as long as they are not 100% at fault. Any fault of plaintiff will be apportioned by the jury or judge and will be calculated considering all parties involved in the accident, whether they are a named party or not. Defamation/slander. Defamation requires proof of a statement of fact, publication of the statement, falsity, damages, and the required level of culpability. Where the plaintiff is a public figure or public official, actual malice is required, which is knowledge of the statement's falsity or reckless disregard for the truth. For a private plaintiff, only negligence is required. Where the defamation is oral, slander, actual damages must be shown unless it is slander, per se. Slander per se is where the defamatory statement relates to a person's business, accuses a woman of being unchaste, accuses someone of moral turpitude or of having a loathsome disease. Assault. Assault is an intentional tort, which requires a showing that the defendant intentionally placed the plaintiff in a reasonable apprehension of an immediate offensive contact or touching. Battery. Battery is an intentional and offensive touching of the plaintiff's person or something connected to it. Punitive damages. Punitive damages are available where the defendant acted with gross negligence or intentional or willful misconduct. They are generally limited to the greater of 3 times compensatory damages or $500,000 unless the defendant was intoxicated, the plaintiff was elderly, or the defendant intended to harm the plaintiff. Intentional infliction of emotional distress. Extreme and outrageous conduct on the part of defendant, intending to cause emotional distress of plaintiff, that in fact causes emotional distress. Invasion of privacy / disclosure of public facts. FL does not recognize a separate tort of false light but does recognize invasion of privacy in disclosing private facts. This tort requires publication of private facts. Comparative negligence / damages. FL has adopted pure comparative negligence, which allows a plaintiff to recover regardless of any fault, i.e. plaintiff can be 99% at fault and still recover. FL also abolished joint and several liability for tortfeasors. Each defendant is only liable for their percentage of fault as long as they can prove the other's fault. All defendants do not need to be before the court to reduce damages. Defamation / libel. Defamation requires proof of a statement of fact, publication of the statement, falsity, damages, and the required level of culpability. Where the plaintiff is a public figure or public official, actual malice is required, which is knowledge of the statement's falsity or reckless disregard for the truth. For a private plaintiff, only negligence is required. Here, the statements were printed rather than oral, so the claim would technically be for libel, which requires no showing of actual damages. To sue a media defendant for libel, however, FL requires that the plaintiff first provide notice to the defendant of its intent to sue and then give the defendant 10 days to retract the statement. If the media defendant retracts and the original statement was made in good faith, the plaintiff can recover only actual damages. Truth will be an absolute defense. False imprisonment. False imprisonment is an intentional tort wherein a defendant intentionally confines an individual by force or threats of force, against their will, and wrongfully. Shopkeeper's privilege. However, in Florida, shopkeepers have a privilege that allows them to detain certain individuals in certain circumstances. In order for the shopkeeper's privilege to apply, the shopkeeper must have a reasonable suspicion that a tort or crime has been committed and then may reasonably restrain the suspect, no force, for a reasonable time to investigate the suspected wrongdoing. Conversion. Conversion is the tort of intentionally interfering with the property of another for the purposes of depriving him thereof. Defamation / slander. Slander is a tort in which an individual / entity makes an oral representation of fact imputing wrongdoing or poor morals onto a plaintiff and made in the presence of third persons. Generally, in order for a plaintiff to recover under a theory of slander, he must prove that he was damaged. However, slander per se exists when a crime of moral turpitude, such as larceny, is imputed to a plaintiff. In such a case, no damages need be proven. If employee statements indicating that customer was a shoplifter were made in the presence of third persons, employee may be liable to customer for slander / defamation. However, for a defendant to be liable to a private person for slander, his statements must have been made negligently. Qualified privilege. A qualified privilege exists when a statement, otherwise defamatory, is made by an individual in good faith, with an interest in making the statement, and limited in scope to the interest he has. Battery. Battery is the intentional tort of making an offensive and unpermitted physical contact with a plaintiff or something in the plaintiff's physical possession. Contact will be considered offensive if it would be unacceptable to a person of ordinary sensibilities. Assault. Assault is the intentional tort of putting a victim in apprehension of an offensive contact. A reasonable person standard is applied in determining whether it was reasonable for a plaintiff to apprehend an offensive contact. Intentional infliction of emotional distress. Intentional infliction of emotional distress is an intentional tort wherein a defendant through extreme and outrageous conduct or communication causes emotional distress to a plaintiff. The conduct must be that which would be unacceptable to a person of ordinary sensibilities. Malicious prosecution. Malicious prosecution is a tort wherein an individual prosecutes or causes another to prosecute a plaintiff with no probable cause, in bad faith, and which results in a dismissal of the prosecution against the plaintiff. Respondent superior / vicarious liability. The doctrine of respondeat superior imposes vicarious liability on an employer for torts committed by their employee during the course of the employee's employment. Generally, an employer is not vicariously liable for an employee's intentional torts. However, if the employee committed the tort for the benefit of the employer, as part of his employment, or with the express or implied authority from his employer, the employer will be liable for its employee's torts. Negligence, which requires a duty, breach, causation, and damages. Duty. For the actor to use the level of care as an ordinary reasonably prudent person in like circumstances. Breach. When the standard of care is not met, because defendant acted below the standard. Causation. Requires cause in fact and proximate cause. Cause in fact or actual cause is determined using the but for texts. But for defendant's breach, plaintiff would not have been injured. Direct cause test, defendant is liable for all injuries that occur directly from her actions when there is no break in the causal chain. Damages. Actual damages must be proven. Parent-child immunity. Parent-child immunity has been waived in Florida in cases of a child against their parent for negligence or sexual abuse. Comparative negligence. Florida uses a pure comparative negligence analysis and has abolished joint and several liability. Therefore, a plaintiff can recover damages whether or not he was at fault as well. However, damages are awarded by the percentage of fault attributed to each actor, and plaintiff cannot recover for any percentage that he was at fault. Battery. Battery requires intent to cause harmful or offensive contact with the person of another, an act that does result in harmful or offensive touching, and causation. Permissive use. Florida follows the minority and says that owners of vehicles are vicariously liable for all negligent acts caused by someone who they lend their vehicles to. In addition, it does not matter if person goes out of the scope of their permission, because Florida has also adopted the dangerous instrumentality doctrine that says an owner of a dangerous instrumentality, which includes cars, golf carts, etc., is liable for all injuries caused by the negligence of the person using the instrumentality. Trespass to land. Trespass to land is the voluntary intentional physical invasion into the real estate of another. Causation must also be proved. Implied warranty of merchantability. The implied warranty of merchantability states that, when sold by a merchant, the product will work as intended. Warranty fitness, for a particular purpose. Fitness for a particular purpose breach, which here can only apply to rentals as it involves the store having knowledge of certain facts, discussed immediately now. The plaintiff must show that there is a particular purpose in which she needs the product and she expressed such purpose, the person in the store knew of such purpose, and the product did not work for that purpose. Fraud/misrepresentation. Intentional misrepresentation occurs when there is a misrepresentation, there is scienter, the party relies on the misrepresentation to buy the product and is harmed by it. Negligence. In order to establish negligence, a party must show that there is a duty, the duty was breached, causation, and damages. Strict product liability. Torts law has a particular category as it relates to products liability, which allows a plaintiff to recover against a retailer or manufacturer, any person in the stream of commerce chain, if certain circumstances are met. In order to show strict liability, a plaintiff must show that the party at issue was a merchant, that there was an unreasonably dangerous condition of the product, that the product was in the hands of the defendant, i.e. that it was in the defendant's control so that a third party would not be the one responsible for any damages or changes to the product, and that the plaintiff made a foreseeable use of the product. First, there can be a manufacturing defect so that only that one particular product is defective, there can be a design defect so that all products are defective, or there can be a failure to warn. Intentional infliction of emotional distress, which requires that a party act outrageously, and such outrageous behavior causes emotional distress. Product liability. Generally, a seller, designer, or manufacturer of a good is liable for any product it places in the stream of commerce which is improperly designed or constructed and thereafter causes injury. Negligence. Generally, as action sounding in negligence requires there to be a duty owed to some party, a breach of that duty, a showing that the breach is the actual and proximate cause of the injury to the plaintiff, and then a result of damages from that injury. Generally, a plaintiff must show that the breach was the actual cause of his injuries, i.e., but for the breach, plaintiff wouldn't have been injured, and the proximate cause, i.e., it is foreseeable from the defendant's perspective that plaintiff would be injured by this breach. There are two general views on foreseeability. The Cardozo approach holds that the plaintiff must be in the zone of danger to be considered foreseeable. The Andrews approach requires that a plaintiff being injured makes him foreseeable. Superseding causation. Generally, a superseding intervening cause is some action or event that occurs which cuts off defendant's liability. Fraudulent misrepresentation. Generally, the tort of misrepresentation occurs when a party negligently, or fraudulently, asserts or withholds knowledge to or from the buyer which he knows, or should know, is false, the buyer relies on that information, and is damaged. Comparative fault. A plaintiff may join any defendants whose allegedly tortuous conduct arose from the same transaction and or occurrences, T/O, and such defendants will be held liable to their proportion of fault. Florida has abolished joint and several liability, which means that each defendant pays his percent of plaintiff's recovery proportionate to the defendant's percent of fault. Florida also follows a pure comparative liability rule, which means that a plaintiff's recovery will be proportionately reduced by his percentage of fault in causing the harm of which he complains. However, if a jury finds that a plaintiff is more than 50% at fault and also finds that plaintiff's 50+% is due to voluntary intoxication, plaintiff will recover nothing. Vicarious liability. An employer will be held liable for the acts of its employees if 1. The employee's act was done within the scope of the employee's duties. 2. The employee's acts were not willful or wanton, unless the employer authorized or otherwise authorized the willful/wanton conduct. 3. Normally, employers are not liable for their employees' torts against the body of a person, battery, false imprisonment, etc., but an employer may be held liable for such torts if physical contact with customers is a part of the employee's job, e.g. bouncer at a nightclub. Merchant. A merchant may be held liable to a customer if the merchant, 1. Makes an express warranty about a product and its characteristics/performance, not mere puffery, 2. And the product does not live up to the express warranties. Strict products liability. A manufacturer and distributor of a product will be held strictly liable for injuries caused by that product if the product was unreasonably dangerous. The product left the manufacturer in this dangerous condition. The distributor did not alter the product. The product was dangerously defective in one or more of 3 ways. Defectively manufactured. The product was properly designed but somehow was made defectively in the manufacturing process. Safeguards against defective manufacturer are no defense to this claim. Defectively designed. The product was defectively designed, making it unreasonably dangerous, and there was no other economically reasonable way of making the product to serve its intended use at a commercially reasonable price. Defective. Warnings. The product was properly designed and manufactured, but the product lacked warning labels and/or instructions that would have put an average consumer on notice of dangerous aspects of the product. Such warnings must be conspicuous, legible, clear, and understandable. The consumer made foreseeable use of the product. Such use does not have to be the intended use, just foreseeable use. The product caused injury. The consumer suffered harm. Mere economic loss to the product is not enough to prevail in this claim. There must be damage to the consumer or the consumer's property. If there is only damage to the product itself, the proper cause of action is breach of contract. A plaintiff must show both actual causation, that but for the defendant's conduct the plaintiff would not have been injured, and proximate causation, that is, plaintiff's injury is the kind of foreseeable risk that this defendant should be held liable for. The eggshell plaintiff. A defendant takes his plaintiff as he finds them. Hence, the defendant will be held liable for any harm to the plaintiff that arises from his tortuous act and is attributable to plaintiff's condition. Defendant's liability may be limited or severed through unforeseeable intervening acts, but rescuers and medical malpractice and injuries arising from treatment are foreseeable and therefore are not superseding intervening acts, but they might lessen defendant's percent of fault. Negligent hiring. An employer can be held for negligent hiring if the employer knowingly hires a person who is not qualified for the job or the person has a record of behavior that makes him a danger to the employer's customers/charges. Negligent hiring is one of the rare civil torts in which the character of the defendant is at issue, and therefore the court will allow evidence as to character otherwise banned from consideration in most torts. Negligence. In order to have a cause of action in negligence there must be a duty, breach of that duty, foreseeable harm, both factual and legal, and damages that result. Drivers on the road have the duty to act as an ordinary reasonably prudent person under the relevant circumstances. This duty does take into account physical aspects of the defendant's character, but not mental abilities, and it is applicable to all foreseeable plaintiffs within the zone of risk of the defendant's conduct. A breach exists where the defendant does not perform as a reasonably prudent person would under the circumstances, and as a result there is a foreseeable injury to a plaintiff in a foreseeable way. Legal causation serves as a foreseeability test and will actually limit the liability of the defendant where the injury that results was unforeseeable. A plaintiff is entitled to recover all compensatory damages, past and future economic and non-economic damages, and at times punitive damages if they are plead as a result of a defendant's misconduct, gross negligence, intentional damages. Negligence, per se. Where there is a statute involved that prescribes the standard of care to be followed by an individual, if a violation of the statute results in harm to a plaintiff of the class intended to be protected from that type of harm, then the plaintiff is able to establish negligence per se. Comparative negligence. In Florida, a driver is comparatively negligent, and his recovery offset, as a result of his failure to wear a seatbelt where one is operational within the vehicle. Rescuer duty. The original tortfeasor is liable for injuries caused by a rescuer as a result of placing the plaintiff in the original damage. The rescuer, however, is liable for his own negligence. While there is no duty to render aid to an injured person absent some relationship, contractual, familial, business, etc., once a person makes the choice to render assistance, they must do so as a reasonably prudent person would under the circumstances. While Florida does have a Good Samaritan statute, the statute does not provide relief for a rescuer who is not a doctor in an emergency setting or a healthcare provider voluntarily providing care to a non-patient in an emergency. Malpractice. Where one sues a doctor for malpractice in Florida, there must first be a pre-suit investigation conducted prior to filing the suit. Before notice to the parties, the plaintiff must have a doctor investigate the cause of action to determine that it is legitimate, then the plaintiff must provide notice to all parties involved, 90 days prior to filing suit. The notice must include the affidavit of the investigator. During the 90 days, the statute of limitations is told and the defendant investigates the action and determines whether he will offer settlement, deny, or admit liability and litigate the damages. If the parties determine to litigate the damages, then they may elect to go to arbitration. If arbitration is unsuccessful, then the plaintiff has 60 days or the remainder of the statute of limitations to file suit. In arbitration as well as in court, there is a cap on the damages recoverable in malpractice cases. If the plaintiff decides to go to court on the issue of damages and forego arbitration, then the cap is $350,000 as opposed to $250,000 in arbitration. The cap in court for a disabled person in an emergency setting ranges from $1.5 million to $500,000 depending on the damages. A practitioner must show that he behaved as a practitioner in similar standing according to the similar community standard, and acted accordingly as a prudent practitioner would. Florida also takes into account specialty. Joint and several liability. The doctrine of joint and several liability was recently abolished in Florida. Each defendant in this case could be joined and the amount of damages for each allocated to that party. If there were joint and several liability, then the court would first deduct any damages attributable to the comparative negligence of the plaintiff. Florida uses a pure comparative negligence, which allows the plaintiff to recover regardless of his amount of fault. With joint and several liability, all defendants would be liable for the entire amount, although the plaintiff would be entitled to only one recovery. The paying defendant would then seek contribution from the other tortfeasors. Currently in Florida, without joint and several liability, the damages to each defendant would be apportioned and the plaintiff would be able to recover only that 16 amount from each defendant. If a negligent party is dropped from the case, that party may still be liable as a fabre defendant, and the damage is offset by the amount of that tortfeasor's liability. Landowner duty, business. As owner of the pub, O owed a duty to his patrons to keep the public areas of the premises reasonably safe, and to warn his patrons of any dangers. Because his patrons are public invitees, owner must make reasonable investigations and maintain his premises in good repair. Bar owner duty. Under FL law, tavern keepers owe a duty to not serve known minors, hopefully not Mr. Duke, ESP since named, to protect patrons, and to not serve known drunks. Rescuer. Many states have Good Samaritan laws that protect rescuers from negligent actions in the course of a rescue, holding rescuers liable only for gross negligence, intentional misconduct, or willful and wanton behavior. The policy is to encourage people to take affirmative acts when they are generally under no duty to do so. Florida's Good Samaritan statute, however, does hold rescuers liable for their negligence. Florida's Good Samaritan statute extends protection to emergency room, ER, doctors as well. Florida protects ER docs so long as their conduct is not reckless. Trespass to land. Trespass to land is the intentional entry onto land of another without consent. Attractive nuisance. Florida's attractive nuisance doctrine applies to children who are lured onto another's land by an artificial element. Duty owed to trespassers. The duty owed by a landowner to a person on his land is dependent upon the status of the person on the land. Greater duties are owed to invitees than to licensees than to trespassers. Trespassers are further classified as known or unknown. The general duty owed to unknown trespassers is to not inflict any affirmative harm, e.g. no spring guns. Since they are unknown, by definition, there is no duty to warn them of hazards on the property. In contrast, some trespassers are known, and they are owed the additional duty of warning of any hidden trap on the property. Intentional infliction of emotional distress. Intentional infliction of emotional distress requires extreme and outrageous conduct by the D resulting in emotional injuries to the P. Negligence. To show a prima facie case in negligence, P must show that I, E had a duty to P, that 2, E breached that duty, that 3, the breach was the actual and proximate cause for P.S. injuries, and 4, damages to P.S. person or property. Landowner duty, business owner. Everyone is owed a duty to act as an average, prudent, reasonable person under the circumstances. Patrons during regular business hours are invitees and owed a higher duty of care, which includes inspecting the premises for unsafe conditions and once discovered, make the condition safe or warn of the condition. Damages. P must have suffered damages to his person or property. Pure comparative negligence. Florida follows pure comparative negligence, therefore, any fault on P.'s side will reduce the liability of E proportionally. Intentional infliction of emotional distress. P would have to show that he engaged in outrageous conduct towards P, that he intended this conduct, that his conduct caused severe distress to P, and that it was foreseeable and intended by E to cause such distress in P. Defamation. P would have to show a publication of a false fact by E to others that concerned P. Battery. Battery is the intentional offensive touching of another without that person's consent. P would have to show that this touching was the actual and proximate cause of injuries to P's person. Respondent superior. Employers are liable for the tortuous acts of their employees within the ordinary scope of employment. Negligent training and supervision. M was under a duty to act as an ordinary prudent person under the circumstances, and employer train their staff and should train their staff concerning their responsibilities of removing dangerous conditions in the store. Negligent hiring. M owed P a duty of reasonable care in the selection of its employees. Punitive damages. Punitive damages must be pleaded with specificity, and the pleading must show intentional or grossly reckless conduct of the tortfeasor towards the plaintiff. Wrongful death. A wrongful death action may be commenced to address a loss of life resulting from tortious conduct. Such is often dependent upon whether the deceased is single or married, a minor, 25 or under, has surviving parents or children, in terms of claims and awarded damages. Damages may include loss of consortium for husband and a child, future earnings, medical expenses, funeral expenses, etc. Strict liability. Florida law provides that a dog bite is strict liability for the owner, regardless of whether dog had propensity to bite or a history of biting/viciousness. Defamation. In Florida, in order to prove a defamation action, the plaintiff must be able to plead and prove the following. A statement was made by the defendant about the plaintiff that it was false, misleading, or detrimental to plaintiff's reputation, and that it was published to one or more persons. In addition, libel per se will exist, and therefore give plaintiff an easier time in proving damages in her action if the defendant has made a defamatory publication regarding such areas as plaintiff's work, her criminal background, plaintiff's morals, or her reputation for unchastity. The difference between public and private plaintiffs is that a defendant will be liable to a private plaintiff for negligence, while a public plaintiff in order to prove damages must prove actual malice. Media defendant, defamation. There are additional requirements when a plaintiff desires to sue a media defendant. 5 days before a prospective plaintiff wishes to file an action against a media defendant, the plaintiff is required to send a letter with notice to the media advising them that she is about to file a lawsuit. The media defendant is then permitted 10 days to file a retraction letter. This retraction letter does not allow the media to escape all liability for damages, but instead may show a lack of malice on the part of the media defendant. Damages. In a defamation case, a private plaintiff is not required to show actual damages. She can show damages by way of the damage to her reputation. Additionally, if activist is successful in proving libel per se, she does not need to prove damages at all. Punitive damages. Punitive damages are available in Florida if proven, for up to 3 times the compensatory damages or $500,000, whichever is greater. Misappropriation. There is probably not a cause of action for commercial appropriation, as this tort usually requires that the plaintiff show that the defendant is using her name or likeliness for a commercial advantage. This is usually proven by way of the use of a celebrity's likeliness in an advertisement or commercial promotion. Intentional infliction of emotional distress. In order to have a claim for intentional infliction of emotional distress, a plaintiff must prove that the defendant's intentional or reckless outrageous behavior caused the plaintiff extreme emotional distress. Outrageous behavior is behavior that is so outrageous that it goes beyond all bounds of common decency. This is judged by an objective standard. Although IIED is an intentional tort, the defendant can be guilty of it if he was reckless, meaning that he acted with a conscious disregard that his behavior would produce a certain result. Although the plaintiff need not prove physical injury, he does need to prove that there has been some manifestation of the distress. It is not enough that the plaintiff sometimes has difficulty sleeping or as a result of the incident, he can't focus or concentrate. Torts of their children. Under common law, a parent is not liable for the torts of their children. But, a parent can be found guilty of negligence directly attributed to them if they have a duty to watch over their children and fail to, or if they are aware of their child's dangerous propensities and fail to warn people of them or to protect others from them. Mr. Smith would have to prove that the parents had a duty to supervise the child, that they breached this duty, that the breach of this duty was the actual and proximate cause of his injury, and also that he suffered damages.